Welcome to Washington Policy on the Go. As you can see, it's a bit of an unusual format today. We had a lot of technical difficulties, so we're operating with the web camera instead of our usual higher quality camera, so we apologize to that. That means Paul and I are going to be really close, kind of like newscasters, squishing together here to make sure that we can deliver the program to you. We're going to talk about Supreme Court decisions today, specifically the Chevron decision and the presidential immunity decision, and then we'll talk about net access decisions with Donald Kimball, who works with me in communications, but has also done some tech work for us. So we'll be talking with him about that and get you apprised of what's happening with SCOTUS. Then we're going to start, obviously, with Paul, who's here in the room with me. He is our senior researcher. Paul, you've been following these stories. One of the things I noted is a lot of our staff were all excited about Chevron and there's a popular internet meme with a young guy in front of a looks like a freshly dug grave, doing the same things.
Putting Chevron away?
Yeah, putting Chevron into the ground, just burying that thing. What does that mean? I mean, for some people, they're going to hear that and think, well, what's wrong with that gas station? But when we're talking about the decision, what is it about this? What was at stake in this decision, and what did the Supreme Court say?
Right. So I'll start from the beginning. In fact, as we often do at Washington Policy Center, I'll start way at the beginning, which is the idea of democracy when our Constitution was written, is that self-government works this way. We vote for representatives. Those representatives go to the state legislature or to Congress and pass laws, and then we live under those laws as they're administered by government agencies. That's the concept. What happened in the early 1980s is that the Reagan administration wanted to ease up on some EPA regulations that were limiting emissions. The EPA did change the regulations in the direction of deregulating, and this is the irony of it. And then the Natural Resources Defense Council, which was an advocacy group that wanted stricter regulations, took the EPA to court in a case called Chevron, and the court ruled in favor of the government agency, in this case, the EPA. And what the court said under Chevron is that the courts have to give deference to an executive branch agency that makes changes in a government regulation if the Congress has not been explicit in the law. In other words, if the law is somewhat vague, then we have to defer, the courts do, to what the expertise of the government agency that is changing the regulation. Conservatives hailed this decision at the time in the 80s because the Reagan administration was using its agency authority to move in the direction of deregulating. The irony is that only lasted for 10 minutes back in the 1980s. Pretty soon the Democrats were back in charge, and guess what happened? Government agencies took what's called Chevron deference, that everyone else, the courts, the citizenry, has to defer to a government agency's interpretation of what the law says. And after that, as we've all lived with for the last 40 years, it was off to the races. Now it's a common experience every day for people to experience government agencies that hand down a regulation that affects your business, your home, your life in some way. And average citizens are saying, where did this rule come from? I don't remember Congress passing a law like this. And the answer is, Congress never passed the law that's affecting you. It was created by some government agencies. When citizens go to sue in court to get their rights back, the courts defer under Chevron to whatever the bureaucratic agency has said. Okay, that's the background. What happened earlier this week is the Supreme Court finally overturned the Chevron precedent case. That's where the grave digging comes on, like that case is gone. And Justice Roberts wrote an opinion saying that, and what we would argue is returning to representative democracy, and that is when the law is vague, that's not the same thing as Congress giving authority to an agency to just make up their own version. Instead, Congress has to be explicit about what the law says. Otherwise, it doesn't have any effect.
That's really interesting. I mean, one of the things that you're talking about is a replacement of the congressional power of lawmaking into the hands of unelected people. And I just had this conversation the other day with somebody who was saying that to fix our problems, we just need term limits. And I said, well, What about the civil service? What would happen there? And
they're not term limited.
Yeah, under this, the civil
So-
service has a great deal of power.
Right. So the left is screaming, as you would expect, over two complaints. One is stare decisis. They're like, this decision was made 40 years ago. It's already in place. It shouldn't be changed. Justice Roberts addressed that. And the second one was a power grab, supposedly by the courts, in interpreting what the law says. The reason those two objections are not valid is number one, Justice Roberts pointed out that the Chevron decision has always been in flux from 1984 to today, which is the courts have been constantly adjusting it. The decision has been cited more than 18,000 times in past cases, and Justice Roberts said it had become unworkable. And so, in other words, instead of a standard that everybody could rely on, it needed to be completely reworked. So that's his idea about going back and revisiting a court decision that had been made in the past. The second part, the second criticism is even less valid, I would say, because how is it a power grab to return to a normal constitution balance of powers where the people elect a representative, goes to Congress, enacts a law. When there's a question about the law, the courts decide what the law says based on what Congress passed, and instead of deferring to an unelected bureaucrat. And you're right about term limits, which is people who work in government agencies, of course, are completely insulated from the voters and can serve there. As we saw with Dr. Fauci, they can be in office for 40, 45 years. And the other point that people don't realize about how this played out in practice is that Congress, which doesn't like to do things that are unpopular, especially when it comes to imposing more rules and regulations on the public. And so what Democrats in Congress would tend to do, but both parties sometimes, is pass a law that was vaguely written on purpose with a kind of a wink and a nod to the government agency saying, you know, we expect you to do the hard stuff and enforce this. And then when our constituents turn to us and say this regulation is killing us, congressmen are able to say, well, we didn't have anything to do with that. You know, that was the EPA, that was the housing agency or some other regulation. So this returns accountability to people who should be making our laws and who at least have to face the voters every 2, 4, or 6 years.
Seems like an exciting decision, except if you're a congressman, it means more work because they're going to have to get better and more specific when they actually write things.
And if you want a government agency to do something, you're going to have to give that explicitly in the law, and then, of course, be accountable to the public for that.
Is there a specific application that you can think of to Washington State where, you know, are there any decisions or anything that you think of where, hey, this is going to have an immediate impact?
Yeah. So one is, I mean, there are lots, but I'll just touch on a couple very quickly that have affected us. One is the Endangered Species Act. So there are a species of salmon have been designated that way, which is fine if Congress has authorized that. But that's an area that has affected everybody in our state. And the more accountable Congress is, it protects us from what the bureaucrats are doing. And the other one is an act that maybe people have heard of called the Waters of the USA, which is being proposed. But there again, that would create a regulation that affects literally like every stream and pond and drop of water in the entire state. And if those regulations are going to go into place, they should come directly from Congress, not be imposed by agencies.
Yeah, I always find it troubling when I hear that a law doesn't pass Congress and it's proposed, and then usually it's some progressive thing, and then they say, well, we don't like that, so the executive will direct the legislative or the administrative branch to find some way to squeeze it into something that it didn't actually apply to. I mean, there's just no. You could go back and look at the debate, and you'd see there was no mention of that whatsoever. I find that to be a troubling habit, especially for those who are saying that they care about rule of law. I mean, the process matters because people have to be able to feel like the rules are being followed, you know.
Exactly. And again, this is a core democratic principle, which is we know that in, you know, tyrannical and abusive systems like the Soviet Union, for example, or in China today, the rules are not actually written down so that people, they don't know when they violated a rule. So that's the most abusive part of this principle. But even in a lighter sense that we've had in the US, to just be trying to run your business and be unsure. I'll give the case of how this came up, is that there's a family-owned fishing business in New England, And the agency that oversees their fisheries had decided that they needed to have inspectors on the boat at sea, and that the cost of having that inspector, which was about $700 a day, was going to be borne by the business.
Oh, geez.
And so that's the family, called Loper is the name of the family. They sued and said, where did this rule come from? And that's the case that eventually worked its way up to the Supreme Court.
Wow, that's amazing. And good for them, actually, for fighting it. That's
I can add one other thing
Yeah,
too.
please do.
This Loper decision that overturned the Chevron case comes one day after another case in which the Supreme Court struck down a rule by the Securities and Exchange Commission that where the agency, completely on their own, had said that civil penalties could be levied by the agency using an administrative law judge. Maybe you heard of this case.
Yes.
Instead of allowing the citizen to go to trial. So there's another case of where the Supreme Court kind of did a two-step in which they told the Securities and Exchange Commission, you can't deny people their Seventh Amendment right to a trial by jury.
Was that the opioid controversy?
It was like an insider trading case from a number of years ago. It actually dated all the way back to 2008. But eventually this bond trader who had been charged by the SEC eventually won his right to a trial by jury. But the point is that you see that what the court is doing is that the Roberts Court is returning core civil rights to the citizens. And the more screaming and protest I hear from the left, that generally tells me that they're probably on the right course.
Yeah, it's interesting. A lot of the criticism you see that it's like, they'll use the terms like power grab, out of control courts, and things. Generally, power grabs usually power grabs mean I'm taking the power and so that I decide for you. These are decisions that they're saying, no, this power belongs over here and this power belongs over here and over there.
Yeah.
It's a totally different thing.
So again, the pattern that we see almost in every issue we deal with is that when it restricts the control that government has over your daily life, people on the left tend to oppose that and people on the right tend to support it. So that's the pattern that we see.
One more thing on these cases, and that is, obviously you wrote a great deal and edited a lot of the policy guide. And one of our recommendations in Washington State is we have this mountain of regulations that keep thousands and thousands of pages of Washington State where they don't grandfather. So I thought it was interesting on a mini level. Washington State needs its own approach on this. I know we have that recommendation in there, but we're out of control when it comes to outdated or administrative code and the same kind of thing where the legislature's or the executive is just allowing administrative codes to be written that radically change policy.
Yeah,
and they doesn't pass a legislation.
And they never disappear.
Right.
So we do have that problem. On the one hand, our state legislature does the same deference to state agencies. It's like they tell the bureaucrats, you go out and be the enforcers that the public sees, and therefore the legislature doesn't take accountability. But we have recommended that there should be an automatic sunset of all regulations. Every 3 years, every 5 years, there should be a rotating calendar where regulations automatically expire unless the legislature reauthorizes them, which they could do very easily. When I run into this argument, I hear from lawmakers, they say that's impossible, the workload would be incredible. And I said, it's not hard to pass a one-sentence bill that says this regulation is reauthorized for another 5 years.
Yeah.
But at least there would be a stopgap.
Yeah, and you could have a public hearing, and if nobody shows and says there's a problem with this group of regulations, because people would show. I mean, the people with interest in that area would find a way.
Exactly, and would also set a time limit where even the government agency themselves would start to hear from the public.
Yeah,
we can't wait for this regulation to expire on a certain date. And by the way, don't reauthorize it again. So that would be a healthy step.
Yeah, I think so. There was another case that you were following, and that was the presidential immunity case.
Yes.
Where there's, in fact, I just had this conversation this morning with somebody totally unrelated to WPC. I was in an office and they turned and said, well, I guess, the president's immune from anything now. And I said, I don't think that's really the way it works. The Constitution's something else. Why don't you describe what the challenge is and what the court actually said about presidential immunity? Exactly.
So we always start with the basics, which is, where did this issue come from? It's like, why are the courts dealing with this? If you think about it, our republic has existed for 250 years. We've had 46 presidents, and this issue has never come up before. In other words, the idea that a former president could be arrested, a former president's home could be raided, a former president could be indicted 4, 5, 6 times. So to us, that indicates that something new and unique is happening today that's never happened before because the courts have not dealt with this issue. You could imagine a case in the 19th century in which there was a corrupt administration and the courts had to deal with a corrupt president who took bribes or something like that. Never came up. So that means that this particular issue is unique to today. Of course, we all know the reason that it's come up. It's because Donald Trump has been indicted and he is going through this court process. What the Supreme Court ruled was that the president is immune for his official acts and not his unofficial acts. I actually think the court was clever in not being too detailed. In other words, they didn't say, we're going to sit here and decide here's a list of things that are okay and of things that a president can't do.
Yeah, here's official, here's
right, here's unofficial. We're going to define that because, of course, that's impossible, number one. And number two, the court is thinking in terms of long-term congressional or constitutional principle. I don't even think they're thinking about Donald Trump that much because they know that all these cases with Trump will be resolved in some way in short order. Or you can even imagine a scenario in which Trump wins the election. And now Trump is in a position to pardon himself if he wants to.
Right.
So in terms of that individual person, I don't think that matters that much.
Yeah.
What the court is thinking about is future presidents. And the Roberts Court made it clear that a future president should be able to act and make bold and risky decisions on behalf of the country without having to think to himself, am I going to go to jail for this someday? So that's where they were trying to protect him. At the same time, they made it very clear that if there's an obvious personal action that the president takes or breaks the law, then he could be held accountable for that.
That's like there's a lot of hyperbole on news shows. You know, the president could murder somebody, and it's like that. That's not what's being said here.
Yeah, it's hard to imagine serious legal offenses as being defined as an official act.
Right.
There's also another check which the court didn't go into, but exists naturally, and that is there's always the possibility that Congress can impeach a future president for an offense.
Right.
If the president is convicted in an impeachment, he's thrown out of office. Okay. And at that point, he is definitely liable to prosecution for whatever act that he took. In that case, the safeguard is Congress itself.
Yep.
If Congress says this was a violation of law, it's an unofficial act, or the president acted improperly, that creates the possibility of prosecution in the future.
Well, thank you. Are you writing a blog on that by any chance? Is there...
Yes, I'm going to be putting up short descriptions of both these cases. And again, there's a lot of commentary about these cases, but what we're trying to do is to provide that value added kind of fresh view that other people don't see.
So you see that at WashingtonPolicy.org. Thanks, Paul. Appreciate it.
You bet. Thank you.
You bet.